Secretary of State Franco Vomero.
Yes, well, there seems to have been some anonymity in the lower court, but we can see no good reason for anonymity, and neither does Mr. Hussain, so anonymity there will not be.
My Lady, my Lords, I'm grateful. I appear in this matter with Mr. Ben Lask to my right on behalf of the Appellant Secretary of State. On behalf of the respondent, who I shall for convenience continue to refer to as FV, even if he's not reported as such, on behalf of the respondent, Mr. Raza Hussain of Queen's Counsel appears, and Professor Takis Tridimas and Mr. Nick Armstrong. My Lady, my Lords, I propose to structure my submissions in this way. I will first briefly alight on the relevant provisions of the directive and the implementing regulations to identify the relevant provisions with which the Court is concerned. Secondly, I will address the scope of the issues on appeal. And then thirdly, turn to the two limbs of the Secretary of State's appeal. First, that FV did not acquire a right of permanent residence under the directive by reason of his imprisonment, and therefore has neither the benefit of protection of Article 28.2 or Article 28.3a, and that even if he acquired a right of permanent residence by reason of imprisonment, he has lost it. And or secondly, if he does have a right of permanent residence, he has nonetheless lost the protection of Article 28.3a in any event. So turning briefly, I hope, first of all, to the directive, that is to be found in the Authorities Volume 1 at Tab 2, MS 506. The recitals begin materially at page 511, and I shan't dwell on these as they are well rehearsed in the case law to which we'll come in due course. We point up recitals 17 and 18, emphasising that the enjoyment of the right of permanent residence is a function of integration. It is a genuine vehicle, as recital 18 puts it, for integration into the society of the host member state. And then at 513, recitals 23 and 24, noting at 23 that expulsion on grounds of public policy or public security is a measure that can seriously harm persons who, having availed themselves of the rights and freedoms conferred on them by the treaty, have become genuinely integrated into the host member state. Again, the link is made between the exercise of the rights and freedoms conferred on individuals by the treaty with genuine integration. And the scope for such measures should therefore be limited in accordance with the principle of proportionality to take account of the degree of integration of the persons concerned, length of residence in the host member state, and other matters, including age, state of health, family, economic situation, and links with country of origin. And then recital 24, accordingly, so making a direct link with the previous recital, the greater the degree of integration of union citizens and their family members in the host member state, the greater the degree of protection against expulsion should be, going on to provide that only in exceptional circumstances where there are imperative grounds of public security should an expulsion measure be taken against union citizens who have resided for many years in the territory of the host member state, in particular when they were born and have resided there throughout their life. Then goes on to reference to the position of minors. So far as the provisions of the directive itself are concerned, only necessary to go to 3 or 4. On page 522 is Article 7, which is the right of residence for more than 3 months, which is conditional upon the exercise of one of the freedoms under the treaty, familiar territory workers, that the those who are self-sufficient.
Mr. Palmer, will you just forgive me for a moment? I'm wondering whether my lords are experiencing the same problem that I'm experiencing in navigating the electronic bundle. No, you're not.
Yeah, it's all right. Yeah.
Well,
If you could tell me I've got a printed version which says, for example, in Article 7, MS page number 522.
it's okay, we've all got the printed versions, but I prefer to work on the screen.
No.
But,
If you could tell me the difference between that number and
no, that's not the point.
Oh.
The document isn't working.
I see.
My lady, we have a spare stick, if you'd like to try that.
Oh, I say, a spare stick. That's wonderful. Yes, I'll try that. But it's very weird.
I see.
It's working on the bookmarks, but it's not working on the page. The page
thought maybe
navigation.
there was a difference in the pagination.
I think, yeah.
It's just mine.
I'm glad we don't
Thank
have
you very
that
much.
difficulty, at least.
So, do carry on. Sort myself out.
If I can carry on, I was on Article 7, just emphasising that the right of residence beyond 3 months is conditional upon being a worker or self-sufficient, a student, or over the page, a family member. That provision appears within Chapter 3 of the directive, as you can see on the previous page, just above Article 6. When one turns to Chapter 4, which is MS 534, the right of permanent residence is introduced. And Article 16.1 provides that union citizens who have resided legally for a continuous period of 5 years in the host member state shall have the right of permanent residence there. This right shall not be subject to the conditions provided for in Chapter 3. So those conditions that we saw a moment ago in Article 7 no longer apply once you pass that 5-year continuous legal residence mark. Subparagraph 3 makes provision as to what amounts to continuity of residence for the purpose of 16.1, and it makes clear that short absences or absences for particular purposes there listed do not interrupt continuity. And 16.4 over the page makes clear that once acquired, the right of permanent residence shall be lost only through absence from the host member state for a period exceeding 2 consecutive years. So that's the right of permanent residence. Then at MS page number 542, Chapter 6 appears, which deals with restriction on the rights of entry and residence. And at 27.1, subject to the provisions of this chapter, member states may restrict the freedom of movement and residence of union citizens and their family members, irrespective of nationality, on grounds of public policy, public security, or public health. And then 2, over the page, making clear that measures on grounds of public policy or public security shall comply with the principle of proportionality and be based exclusively on the personal conduct of the individual concerned. And there's some further provision as to that in that paragraph. And then finally at Article 28, on the following page, protection against expulsion. 28.1 deals with what one might refer to as the basic level of protection, which is a simple judgment of proportionality, and it must take into account in that proportionality assessment the considerations there listed. 28.2 is an intermediate level of protection, which applies to those who have the right of permanent residence, and they may not be expelled except on serious grounds of public policy or public security. So that word serious is introduced. So that narrows the grounds which may be invoked, but of course the proportionality assessment still needs to be done. And then the enhanced level of protection in 28.3a, so far as we're concerned, narrows the grounds to those of imperative grounds of public security. And it applies to union citizens, not family members who aren't union citizens, but union citizens who have resided in the host member state for the previous 10 years, and to minors as well in B. So those are the provisions of the directive with which the court is concerned. They are implemented in the Immigration EEA regulations of 2006, which appear at tab 3 and start at MS 553. The regulations came into force, as you can see from Regulation 1, on the 30th of April 2006, which was the date by which the directive had to be implemented. For your note, that is Article 40 of the directive.
Sorry, give me the date again.
30th of April 2006, my lord.
Yes, I've got it. It's in the cases. Yeah.
There are 4 regulations, which I won't turn to in detail, as the parties are agreed they accurately implement the directive's provisions. Regulation 6 at MS 560 defines what, for the purposes of the regulation, is called a qualified person, and they include the categories of persons that you saw referred to in Article 7 of the directive: job seekers and workers, self-employed persons and self-sufficient persons or students. And then Regulation 14 at 573 implements what is referred to as the extended right of residence, which means residence for more than 3 months, and it's qualified persons who enjoy that right. Then Regulation 15, page 574, implements the permanent right of residence. You can see that at 15.1a. And then Regulation 21, which appears at MS page 587, which implements the provisions of Articles 27 to 28, to which I took you a moment ago. So that's the legislation with which the court is concerned. I turn next to the scope of the issues before the Court on Appeal.
Can I ask a question? Are there any relevant travaux préparatoires to assist understand the thinking behind these various provisions and their interrelationship?
None which either party has placed before the court, as we collectively took the view they didn't take the matter further beyond the state of affairs as subsequently interpreted in the case law. Some of the case law does draw on the travaux to a limited extent.
I see. Thank you.
In terms of the scope of the appeal, permission was granted only on ground 2, the Secretary of State. If I take to hand the core volume at MS 92, which is the statement of facts and issues agreed between the parties, at paragraph 20, Paragraph 20 of the Statement of Facts and Issues makes clear that there are 2 limbs of the Secretary of State's appeal under ground 2, as summarised at paragraph 37 of the grounds of appeal, which for your note is MS page 52. The first limb is that the Secretary of State's case is that time spent in prison shouldn't count as qualifying resident for either the purposes of Article 16 or Article 28. And it follows that whereas here an EU national has been sentenced to a significant period of time in prison prior to the deportation decision, he can't benefit from Article 28.3. And the second limb, the alternative limb, was whereas here the time spent in prison exceeds a 2-year period and precedes the entry into effect of the Citizenship Directive, that's the 30th of April 2006, any acquired 5-year period of legal residence does not confer a right of permanent residence after the 30th of April 2006.
When you announced the limbs of the appeal within a minute of standing up, you didn't refer to what I might call the date point, but it is part of the appeal still, is it?
It is, my lord. Indeed, I took it the other way round. I didn't mention the date, but I started by saying our first limb of my appeal, which is in reverse order, in fact, of those two limbs, for reasons to which I'll come, was that FV did not acquire a right of permanent residence under the directive by reason of his imprisonment. And as I'll come to develop in a moment, the reason why we say he did not acquire a right of permanent residence was that on the 30th of April, when that right was created, he had been in prison for, in fact, 5 years, but critically more than 2 years, subsequent to having completed a 5-year period of continuous legal residence.
Very well, thank you.
We say that is the reason why he did not acquire that right. I take it in that reverse order because logically I must first look at whether or not what his rights are and whether or not they were acquired, before then considering what the implications are, first if we're right that he didn't acquire that right, and second if we're wrong and he did.
When we gave permission for this, although there is an issue as to whether you're entitled to raise it?
Well, that is why I'm turning to this point of the scope of the issues on appeal, because I am told by my learned friends for FV that I may not raise this point. I want to show the court that that is wrong, but also to be quite clear as to the limits of the point and what is an issue and what certainly we do not argue. Ground 2, once permission was granted, was stayed, as the court will recall and as the court will see from MS page 81, behind the Court of Justice's decisions in MG and Onukwari. And the court will see from MS page 82 that in November 2014, after the Court of Justice had given its judgment in those two cases, the parties were invited to file submissions as to what should happen next. Those submissions were filed and were referred to a panel of the court, and having considered the parties' submissions, the justices have decided that the permission to appeal which was given should stand. And in brackets, you'll see the words, i.e. the appeal should not be split up, and that the stay should now be lifted. Now, those words reflect the nature of the submissions which were filed to the court. If I may quickly turn up those, they're in Appendix Part 2, first of all at page 332. Which were the Secretary of State's submissions on the lifting of the stay. And at paragraph 2, the Secretary of State started by again indicating that Ground 2 consisted of 2 limbs, as summarised at paragraph 37, and sets out those limbs in the same terms as appear in the Statement of Facts and Issues. And at paragraph 12, at page 335, you will see the Secretary of State's submission in a nutshell on the second limb, which is the date point, which I shan't read out, but you see there at 12.1, 12.2, and over the page at 12.3. So that was advanced as a reason why the appeal should be heard. In response, the respondent's submissions at page 337, you see at paragraph 1, it's directly responding to those submissions. But at paragraph 2, in the final sentence, it was submitted that in the light of MG, the second limb of the Secretary of State's remaining ground of appeal can no longer be said to be arguable. That was said, and I shan't go through the argument as to why that was said at this stage, but at 344 in the final paragraph, for all these reasons, it said, it submitted, it's now clear that the second limb of the Secretary of State's ground is unarguable and should not be permitted to proceed. So FE was in favour of the stay being lifted, but invited the court to allow it to proceed only on the first limb and not on the second limb. It's that to which the court was referring. We see it conveniently at page 345 again. It's the same document.
And you can give me the electronic...
The electronic reference was MS82.
Well, basically, they're arguing that what they say is the nuanced approach relating to the 10-year period also applies to the 5-year period.
They were saying, for the purposes of this scope point, they were saying that we were so unarguable that we should be knocked out on that second limb.
But in the way I've said, that seems to be the argument. There's a lot of reference to the 10-year period, and on UKO and so on deal with that.
But the court rejected that so far as the permission threshold was concerned. And so we say that second limb is before the court as a result of that decision not to split up that ground further and refuse permission in respect of part of it. At MS page 128, which is within the respondent's written case, you see why at paragraphs 7 and 8 it was necessary to show you what I've just shown you, because what is said there at 7 and 8 is that the Court of Appeal considered that it would be unjust to permit the Secretary of State to raise an issue in 2012, and it's asserted at paragraph 8 that Secretary of State sought permission to appeal these further conclusions but was refused by the court. We say that submission confuses two separate points. The first point is this: there is no doubt, and I fully accept, that it must be assumed that by March 2001, which was the date of the crime and crime for which FV was subsequently convicted, the crime of manslaughter, at that date, FV had resided in the UK for a period of at least 5 continuous years in compliance with the treaty. Now, in the court below, the Secretary of State sought to reopen that conclusion and say that had not been conceded by the Secretary of State, had not been accepted, and FV had not demonstrated it. But the Court of Appeal was quite clear that it was wrong at that stage for the Secretary of State to be allowed effectively to put FV to proof of his activities for a continuous period of 5 years, as long ago as up to 2001, so going back through the 1990s, perhaps before. My Lords will see that in the Court of Appeal's judgment at MS 169, judgment of Lord Justice Pill, paragraph 35, where he gave his reasons for concluding that Secretary of State should not now be permitted to argue that a permanent right of residence had not been established. A to F deal with what had been put in issue before the tribunals below. And importantly, at G, what really animates the conclusion, in 2007, neither the parties nor the tribunal had the advantage of the further learning on Regulation 21 and Article 28 now available, but the issue then having been confined as described above, it would be unjust to permit the Secretary of State to raise the issue in 2012. The appellant would be required to rely on events prior to 2001, when he was living in very different circumstances from those subsequently, and now would be unjust to require him to satisfy by evidence the requirements of Regulation 15 so many years after the event and 5 years after the first tribunal decision. And Lord Justice Aikens, at paragraph 126, page 194.
But that's not what you're arguing about now. You're arguing about something completely different, aren't you?
That is the point.
Can we just get on with it?
My Lord, yeah, if the court is content with the point, I just want to be clear, we do not challenge that. Secretary of State sought to challenge that in ground one, but was
Mr. Hussain is not going to prevent us from listening to the point that you do want to raise, which is a completely different one.
I'm grateful.
That's right, isn't it?
I'm grateful, Eddie.
My lady, that is correct. The issue is whether, as a matter of law, Mr. Vomero retained his right of residence, permanent right of residence, in 2006.
Yes.
And the issue with which we contested in our submissions, seeking a splitting up of the appeal, weren't that a nuanced approach was to apply, but rather that retention of right of permanent residence was not an essential prerequisite for enhanced protection.
Oh, I see. Well,
That was the point.
That's of
We've
course a
got
big
that.
issue.
We got that one.
Yes.
Welcome.
But more broadly, Mr. Palmer, of course, these issues have been raised. No doubt we will be dealing with them. Am I not right in saying that the issue before the tribunal was simply whether there were imperative grounds of public security?
Yes.
In other words, the threshold into Article 28(3) wasn't in issue. So I'm slightly intrigued as to how this issue was able to bubble up in the Court of Appeal and continue to bubble today.
Well, the answer is because throughout this period, the Court of Justice's own jurisprudence was developing, and points became available which simply were not known or assumed below, and they were permitted to be argued.
Very well. Thank you.
One clear point that comes out of the provisions of the directive to which I took, my lords, is this, that there's no provision at all dealing with transitional cases, and there's no provision at all dealing with the relevance and effect of imprisonment. And so the Court of Justice has had to, over a series of decisions, decide what should be done about transitional cases, and in particular cases where the 5-year period relied upon happened before the directive came into effect, and what should be done about imprisonment, and whether that counts as legal residence, whether it counts as continuity, and how it affects the levels of protection in Article 28. And that has been a developing picture which the court no doubt has been concerned to give guidance on for all cases and not just this one.
Thank you.
Can I also just ask at the outset, am I right in understanding that the parties are proceeding on the basis that the critical issue is what is the effect of the directive? And nobody's raising the possibility that the regulations might have a different effect.
Well, that is right. And in part because the regulations at the time said slightly differently from how they read now. And the reason is they have been amended over time to keep pace with the Court of Justice's interpretation of the directive. But for present purposes, both parties focus on the directive.
Presumably there's an argument that the directive has direct effect in this respect against the government.
Indeed, yes.
Well, the point that was in my mind was, on one view, the regulations are more favourable to Mr. Hussein's client than the directive is.
Well, at the time, they weren't, because they didn't make provision, for example, for transitional cases. So even if at the time the Secretary of State had, in his original decision, accepted that 5 years continuous legal residence had been completed before 2001, it would have treated that as irrelevant for the purposes of the directive and would have gained no rights of permanent residence under the regulations, because those regulations predated the Court of Justice's decision in La Salle, which made clear that earlier periods of residence do count. So they weren't more favourable at the time.
Mm-hmm. Did the regulations say anything about imprisonment?
No.
No, I didn't think they did.
No. Well, they just refer to they use the word reside and residence,
Yeah.
and in
So
terms
they
of
simply
what
look
that
at
means.
periods of continuous residence.
Yes. So in deciding what that means, one has to interpret it in line with what the Court of Justice says the directive
Well,
means.
that's really the unexplored issue that I was just wanting to check. Nobody was wanting to raise.
Nobody's raised a point. So the first point, my first main submission is this. Assuming that period of 5 years was completed prior to 2001, a non sequitur that on those facts FV established a right of permanent residence as a matter of law as at the 30th of April 2006. The facts are that he was arrested in March 2001. He was held in custody on remand until he was convicted and sentenced on the 2nd of May 2002, and he remained in prison until the 3rd of July 2006, so a few months after that key date of the 30th of April 2006. And as to the position in law, may I just turn up briefly at the Court of Justice's decision in Diaz, to which I'll turn in more detail later on, but that appears in the second volume of the bundle of authorities at tab 10. And for present purposes, I just need page 831 at paragraph 57. The right to permanent residence provided for in Article 16 could be acquired only with effect from April the 30th, 2006, as stated in paragraph 40 above. Consequently, unlike periods of continuous legal residence of 5 years completed after that date, which confer on citizens of the Union the right of permanent residence with effect from the actual moment at which they're completed, periods completed before that date do not allow those persons to benefit from such a right of residence prior to the 30th of April 2006. So I'll return to the effect of that period of imprisonment in a moment, but one thing at this stage we can say with certainty with respect to the Court of Appeal's judgment, in particular the judgment of Lord Justice Aikens at paragraph 103, which is on MS page 188. In the final sentence of paragraph 103, the judge concluded that, like Lord Justice Pill, I've concluded that we must approach this case on the basis that FV had a subsisting permanent right of residence in the UK at the time of the decision to deport in March 2007, and indeed before he was sentenced in 2002. We can certainly say whatever else in this case, that final phrase, indeed before he was sentenced in 2002, is incorrect, because the right of permanent residence did not exist as at that date. But in effect, what is animating the judge's conclusion as to March 2007 here is that because he had completed the 5 years by 2002, or indeed 2001, that was enough for when we got to that magic date of the 30th of April 2006 and subsequently. That's what is in issue before the court. So we say that the respondent's case at paragraph 11a, which appears at page 129, is wrong on this point. Paragraph 11a, about 6 or 7 lines up from the bottom, when it refers to the Court of Appeal's undisturbed premise that FV enjoyed the right of permanent residence at least until 2001, and indeed until 2007. It simply can't be right that he enjoyed any such right until 2001. And we come now to whether he enjoyed it on the 30th of April 2006. So the summary of our case on this second limb of our argument is this: although he'd completed that 5-year period, he didn't acquire a right of permanent residence on the 30th of April by reason of his imprisonment of over 2 years before that date. For that reason, he doesn't acquire the protection of Article 28.2 of the directive, and for that reason, he doesn't enjoy also the enhanced protection of Article 28.3a. I accept at the outset that if that submission succeeds, with the result that he enjoys only what I call the basic level of protection, under Article 27.2 and 28.1, there nonetheless still has to be an assessment of the proportionality of his deportation, taking into account all his circumstances, which will include how long he's been in the country and every other point of relevance, of course. But the threshold applying here is relevant to the outcome of that exercise. As we can see, the tribunal in 2008 itself decided at MS page 202 paragraph 11, where the 2008 tribunal concluded that whatever the phrase imperative grounds meant, the appellant's circumstances did not fall within it. It continued, while the Secretary of State might have had an arguable case that the appellant's deportation was justified on serious grounds of public policy, that's 28.2, it cannot be justified on these facts on imperative grounds of public security. So the difference there between 28.2 and 3A, let alone 28.1, could be material to the outcome, and that assessment of proportionality on a lower threshold, whether 28.2 or indeed 28.1, the basic level, has not been done at tribunal level or since. It will be a matter on remittal for a fact-finding tribunal to do so, based, of course, on the present position, including FV's subsequent offences and periods of imprisonment, 2012, but in all the circumstances. So, contrary to Part 6 of the respondent's written case, we say that if we're right on this central ground of appeal, the consequence would be remittal for that decision to be done. It hasn't yet been done, and Lord Justice Pill, at paragraph 99, on which the respondent relies, that's MS page 187, I won't go to it now, does not indicate that he has done it either. So if we succeed on this issue of law, the heart of our case, we say that is the consequence for the right assessment of proportionality to be done on remittal. So to that I turn to the law to establish my main case, that right of permanent residence was never acquired. The starting point in the case law is the Court of Justice's decision in LaSalle, which is in the second volume of authorities at tab 8. It's MS page 733. It's the Secretary of State for Work and Pensions in LaSalle. The judgment begins from MS 754. I can go straight to the facts, which are at 758. Paragraphs 18 to 19. We can see from a glance at 18 that Mr. Sal completed a period of more than 5 years of being a worker, September 1999 to February 2005. But then at paragraph 19, following that more than 5 year period, she left the UK to visit her mother in France, where she stayed just for 10 months and then returned, where she sought to continue to work. But when she applied for income support, that was refused on the basis that she had no right to reside in the UK. And since now we're post-April 2006, the question became whether she had a permanent right of residence under the directive or not, to establish her eligibility for that income support. The questions are before the court, referred to the court, are at paragraphs 24 to 25. Firstly, concerning whether you can count those earlier periods before 2006 at all, and secondly, as to the effect of a temporary absence following a continuous period of 5 years legal residence. The answer to the first point we see, first of all, analysed at paragraph 33, page 760. The starting point was this was a new right of permanent residence created by the directive. But then for the reasons set out from 34 onwards, that doesn't mean that earlier periods didn't count. And the conclusion at 37 to 38.
Could you just go to 31 as well?
At 31, the court observed, having regard to the context and objectives, the provisions of the directive cannot be interpreted restrictively and must not be deprived of their effectiveness. And analysed from 34 onwards, leading to conclusion at 37 as to why it would be wrong to discount earlier periods. And at 37, 4 lines down, the court said this: the EU legislature made the acquisition of the right of permanent residence, pursuant to Article 16, subject to the integration of the citizen of the Union in the host member state. And as the Advocate General pointed out, it would be incompatible with the integration-based reasoning behind Article 16 to consider that the required degree of integration in the host member state depended on whether that period ended before or after April 30th. At 38, it should be noted that insofar as that right could only be acquired from April 30th, the taking into account of periods of residence completed before that date doesn't give retroactive effect to Article 16, but simply gives present effect to situations which had previously arisen. So that's the answer in a nutshell to the first question. And the second question was whether a temporary absence in this case of 10 months before the 30th of April, but after 5 years continuous legal residence, made any difference. And we can see at paragraph 44, it was common ground that Mr. Sal had legally resided for a continuous period of more than 5 years in the host member state. That is why, at 45, the court made clear that Article 16.3 was irrelevant. As the court will recall, that dealt with what it means to be continuously legally resident and the effect of short periods of absence whilst you gain your continuous 5-year period to qualify. Once you've got that in the bag, 16.3 simply falls out of account, and so it's irrelevant for that purpose. But then it went on at 46 to say, conversely, Article 16.4 deals with the possibility of losing the right of permanent residence. At 48, the court makes clear, of course, the directive doesn't make expressly clear from Article 16.4 what should happen in this particular case of a short absence before April 30th. However, it goes on from 49, having regard to usual Court of Justice interpretive and purposive principles. We can see from paragraph 53 leading to 54, the general scheme and spirit of Article 16. 55, reference to travaux préparatoires there, making clear that the purpose of 16.4 was that after an absence of that duration, that's 2 years, the link with the member state is loosened. And at 56, importantly, inasmuch as residence periods of 5 years completed before April the 30th, 2006 to be taken into account, as is clear from above, Article 16.4 must necessarily apply to those periods. If that were not the case, the member states would be required to grant the right of permanent residence pursuant to Article 16, even in cases of prolonged absences, which call into question the link between the person concerned and the host member state. It follows Article 16.4 is to apply to continuous periods of 5 years legal residence completed before the 30th of April, and in application implies in particular But absences from the host member state of less than 2 consecutive years occurring after 5 years continuous residence are not such as to affect the link of integration of the citizen of the union concerned. So Article 16.4 is a bright line rule. If you've got the right of permanent residence in the host member state and then leave and remain absent from that member state for 2 years, you lose that right. Here the court decides that if you've got a previous 5-year period, but follow that up with a 2-year absence before April the 30th, then come the bright new dawn of April the 30th, 2006, you do not acquire that right of permanent residence.
Do not acquire or may not acquire?
Do not acquire. It's an automatic.
Isn't it that you've lost it?
It's because you never had it.
It never existed.
Never existed.
But in the kind of virtual world in which we're living,
Yes.
You're assumed to have had it and then lost it.
Well, I would put it differently. I would say you simply never acquire it because it didn't exist, so you couldn't have had it. But
the same fact had
but
happened.
it's the same
fact had happened after 06. It would be a case of acquisition and then loss.
It would.
This is a case where it would have been acquired but for.
Exactly so. Exactly so. So I put that as non-acquisition rather than loss. So if FV, on his facts, following his crime in 2001, had escaped undetected from the country and remained abroad until July 2006 instead of in prison, yes, there'd be no question in LaSalle he would not have acquired a right of permanent residence on the 30th of April 2006. That's the starting point established by LaSalle. The next link in the chain on these transitional cases is the case of Diaz at tab 10, MS 798. And the judgment itself begins at page 821. Again, this was a benefits case for which eligibility turned upon whether or not the claimant had a right of permanent residence. You can see that from paragraph 22, page 826. Then 827 are the important facts, paragraph 23, which are important here to have in mind. You can see we're dealing here with a Portuguese national who entered the UK in January 98. Her residence was then divided into 5 periods. For the first 2, she was in work or on maternity leave, so she qualified as a worker for those first 2 periods, which, if you tot them up, exceeds 5 years. So she had that 5-year period in the bag when you aggregate those first 2 periods. She then spent just over a year not working. It's a period of voluntary unemployment before returning to work. So there's on the magic date of April the 30th, 2006, she was in work and was a worker again, albeit that subsequently, from March 2007, she wasn't working. So the essential question before the court, bearing in mind that pre-2006 she had the 5 years continuous legal residence in the bag, what was the effect of that period of a year, that third period? The questions which were referred at paragraph 33 by the Court of Appeal were referred before the Court of Justice had given judgment in LaSalle, and that infected the way the court put those questions. And so that is why, following the discussion from paragraph 34, leading up to 40, the court reformulates the questions. You might say it was likely that the court was going to reformulate the questions anyway, but there was a particular reason here why it reformulated the question.
Well, speaking from recollection, the Court of Appeal in Dias confronted precisely the LaSalle question, which had not then been decided.
That's right.
In Luxembourg, didn't refer it because there wasn't any need, it was already waiting determination, but said whatever the decision is in LaSalle will govern this, and then went on to refer additional questions arising out of period 3. Is that right?
My Lord, that's right.
Yeah.
And then at 37 of the judgment, we can see along the way to that reformulation, it's noting that she was a worker for that time, and at 38, it must be held that she had completed that continuous period. And so at 40, the question arises, what is the effect of the third period? So that at 41, the reformulated question is to ask, in essence, whether the periods of residence of a union system in the host member state, which were completed on the basis of a resident permit validly issued pursuant to Directive 68/360, that's the old directive that governed the right of residence for workers specifically, without the conditions governing entitlement to any right of residence having been met, and which occurred before April the 30th, but after 5 years continuous legal residence prior to that date, are such as to affect the acquisition of the right of permanent residence. So again, it's put in terms of acquisition, that question.
So just to help me to follow this, you need to be a worker to have the right to reside under Article 7. Is that right?
Needn't be a worker.
Yep.
Being a worker is one route to having the right to reside under Article 7.
Oh, well, I'm just wondering, why does it matter if she wasn't working?
In her context, she did need to be a worker, didn't she, Mr. Palmer? You can be either a worker or a family member or one or two other things, but in her case, the relevant qualification was that she was if she was working.
My Lord, that's right, because she had no alternative claim to be a qualifying person before 2006. She relied on being a worker. That was the basis upon which her residence permit had been issued, and that's the basis upon which she sought to rely. So although she could equally have qualified had she chosen to pursue a course of studies, for example, that simply wasn't the fact of her case.
Yeah, is it? Yeah.
So
Is this because of something in the directive, or is it the court reading it into Article 16? I mean, on its face, Article 16 just simply applies where you've resided legally for 5 years.
What the court interprets that to mean, my Lord, is, in particular, putting emphasis on the word legally, is
Article 7 legally.
in pursuit of
That's
the exercise of EU rights.
Okay.
So if even though your presence in the host member state may be legal from the position of national immigration law, if it's not through the exercise of the rights conferred by the treaty, it doesn't fall within Article 16 as qualifying residence. We see that coming through quite clearly from the cases in a moment.
Fine, thank you.
So there were two main points then decided in Diaz. The first is a response to a submission by Ms. Diaz, which you see at paragraph 45. The submission is rejected. She submitted that it didn't matter that she wasn't working during that third period because she had a residence permit which had been issued to her as a worker and hadn't expired. So she could still rely on the issue of that residence permit. So in a sense that her residence, as my Lord will read indicated a moment ago, was legal. That effectively echoes the argument that was put by Ms. Diaz. But that was rejected, and you can see that by going straight to paragraphs 54 to 55. Yeah. Saying that essentially the mere fact that that permit is issued is not the point. What matters, as it's put at 55, are the conditions governing entitlement to any right of residence having been met. Conversely, it may be said, if you fulfil those conditions but haven't in fact been issued with a permit, it's not the absence of a permit which is fatal to your case. It comes down to whether or not you fulfil those conditions.
in a sentence, the permit is declaratory, not, as they put it, constitutive. In other words, it creates no rights. It simply recognises those that are there independently.
Well, that's right. So the answer to Ms. Diaz's submission was, that is not enough to get you home. Now, my learned friends, you see that at 55 being the final conclusion on that point, say that is the narrow basis, as Lord Justice Pill described it in his judgment, of this case. But in fact, that is the narrow basis only of the first limb of this case, the rejection of Ms. Diaz's submission. At 56, the court continues, in light of that finding, the question submitted as reformulated, make it necessary now to examine secondly.
Sorry, where are we now?
Paragraph 56.
Oh, 56, okay.
The court moves on in light of that preliminary conclusion to consider what is the effect on that period of non-exercise of rights. That's what takes us to 57, to which I took the court earlier. And the court continues at 58, 59. To answer the question, what is the effect of a period of absence? Periods of non-exercise of rights here. And at 59 through to 61, it recalls its conclusions in LaSalle. I didn't go through those in detail. You can just see it's recalling its conclusions in LaSalle, which concerned the analogous application of Article 16.4, and then continues at 62. Such reasoning must also be applied by analogy to periods of residence completed on the basis solely of a residence permit validly issued, the worker's residence, without the conditions governing entitlement to any right of residence having been satisfied, which occurred before April the 30th, 2006, but after the 5 years have been accumulated. At 63, even though Article 16.4 refers only to absences from the host member state, the integration link between the persons concerned and that member state is also called into question in the case of a citizen who, while having resided legally for a continuous period of 5 years, then decides to remain in that member state without having a right of residence. Now, I emphasise, pausing at this stage, that we're dealing with before April the 30th of 2006, because as I indicated earlier, once you've acquired that right after that date, you're no longer subject to the conditions of Article 7. You no longer have to be a worker to continue to enjoy a right of residence or any other basis of right. You enjoy it as a function of enjoying that permanent right. But at 64 it continues. In that regard, it should be noted, as the Advocate General has stated in points 106, 107 of her opinion, that the integration objective which lies behind the acquisition of the right of permanent residence, in Article 16.1, is based not only on territorial and time factors, but also on qualitative elements relating to the level of integration in the host member state. As the situations are comparable, it follows that the rule laid down in Article 16.4 must also be applied by analogy to periods in the host member state completed on the basis solely of a residence permit validly issued without the conditions governing entitled to a right of residence of any kind having been satisfied, which occurred before April the 30th and after a 5-year period. Now that is, again, just as in LaSalle, the adoption and application of the 2-year period for which Article 16.4 provides to periods of non-qualifying residence, which is now being treated in an equal manner to absence. And again, we say that is a bright line rule, which is why, without further explanation, at 66, the court concludes it follows that periods of less than 2 consecutive years completed on that basis are not such as to affect the acquisition of the right of permanent residence under Article 16.1. That follows not because of some qualitative, fact-sensitive, contextual judgment. It follows because the cut-off point is 2 years.
Did you say a moment ago that if the 5-year period had been continuous and ended after the 30th of April 2006, then any subsequent 2 years imprisonment would not be equated with absence.
No, my lord, I didn't. I said any subsequent 2-year period of non-exercise of treaty rights would not be fatal to the right of permanent residence, because that's what the right of permanent residence is.
I see, but I see. So then, in that situation, you would then equate imprisonment with absence, would you?
No, there's a further step in my argument when we get to imprisonment.
Oh, all right, we get
but,
to it. Yeah. I mean, it's not relevant in this case, but I just wanted to work out.
Well, it may be. If this first submission were to fail, then it may still be relevant. But
well, we see the sort of the foundations of it really here in paragraph 64, which refers to the Advocate General in points 106 and 107, referring to integration. And then when you look to see what the Advocate General said there, it's not to do with what I'd assumed it might be economic integration she was talking about, but it wasn't. It was to do with unlawful conduct. And the fact that the person was residing unlawfully is relevant because unlawful conduct of a union citizen may diminish his integration.
Well, that's right. I was going to go there next, in fact, because since the reference is explicit to the Advocate General's reasoning in the court's judgment, it's MS 818. And the section of the Advocate General's opinion, it's Advocate General Tristaniak, runs from 101 at the top of the page, which introduces this topic, up to 109.
Applying 16.4 by analogy, yes.
It's 106 and 107 that the court specifically pick out of that analysis.
Yes, well, we've read those.
I'm grateful, Lady. So the Advocate General's focus is on that illegal nature of the residence when that basic condition of the legality of residence, namely working, is not being fulfilled. The court's emphasis is slightly different and focuses more just simply on the non-fulfillment of the condition of working. And it wouldn't matter on the court's analysis whether or not there was a separate legal basis under domestic law or otherwise for residence. But either way, you see the seeds of the point that illegal activity certainly, as well, or indeed when we come to it, imprisonment, as well as not being a period of exercise of treaty rights, reflects unlawful condition and not only doesn't increase the level of integration in the country, but may decrease the level of integration in a country. So if FV, following his crime in 2001, had, rather than left the country, as I suggested earlier, he might have done, had remained in the country, but without working or otherwise exercising any EU right, and had remained undetected and had not been arrested, again, on July 2006, in April 2006, he would not have qualified for a right of permanent residence. So then we come to the specific case of imprisonment, and the third case in this chain is that of Onukwari, which is at tab 14, begins at MS page 887. The judgment begins at 899, and the facts can be taken from the foot of page 901. See at paragraph 10, Mr. Onukwari is a Nigerian national. Nothing turns on that because he was claiming as a family member of a union citizen. He married an Irish national who was exercising her right of freedom of movement and residence in the UK, had children with her, and obtained a residence permit as a family member of a union citizen. He then served a succession of prison sentences, which are set out in paragraphs 12 and 13. The effect of those prison sentences was that he never served a continuous period of 5 years outside prison. But of course, he was at all times a family member of a union citizen. He always qualified to that extent. But the question was, what was the effect of the fact that during that period, which in fact stretched to up to 10 years, he couldn't string together a continuous period of 5 years, which was uninterrupted by imprisonment. So 2 issues were referred to the court, the questions at paragraph 16. But in short, the first question was, does a period of imprisonment count as legal residence? And secondly, did a period of imprisonment break continuity for the purposes of Article 16.1? In other words, as you can see from the second question at 16, could you nonetheless aggregate periods of residence before and after imprisonment, if it doesn't qualify as legal residence? Or is the lack of continuity there fatal to acquiring a right of permanent residence? The answer to the question, does it count as legal residence, was no. That's at paragraph 22. The reasons for that conclusion follow. And materially at 24, having recalled LaSalle and the link to integration, goes on at 25. Such integration, which is a precondition of the acquisition of the right of permanent residence, is based not only on territorial and temporal factors, but also on qualitative elements relating to the level of integration in the host member state, reference there to Diaz, to such an extent that the undermining of the link of integration between the person concerned and the host member state justifies the loss of the right of permanent residence, even outside the circumstances mentioned in Article 16.4 of the directive. See to that effect Diaz at 59, 63 and 65, which we were looking at a moment ago. At the very least, this conclusion shows that a period of imprisonment is equivalent to a period of non-exercise of treaty rights, i.e. it does not add up to legal residence, and so should be treated in the same way as a period of non-legal residence, of non-fulfillment of treaty rights, as the court concluded should be applied in Diaz, and in the same way as absence, as was the case in LaSalle. Arguably, at least, 25 goes further, because it uses not the language here of non-acquisition in the particular circumstances of 5 completed years and so forth, but uses the language of loss of a right of permanent residence. And the court goes on at 26 to say the imposition of that prison sentence is such as to show the non-compliance by the person concerned with the values expressed by the society of the host member state in its criminal law, with the result that the taking into consideration of periods of imprisonment for the purposes of the acquisition by family members of a union citizen who are not nationals of a member state of the right of permanent residence for the purposes of Article 16.2 would clearly be contrary to the aim pursued by that directive in establishing that right of residence. So the conclusion is periods of imprisonment do not count as legal residence, and the direct analogy is drawn with the loss of integration, the undermining of the link of integration as it's put, as was identified in Diaz, justifying the loss of that right, even outside the circumstances mentioned in Article 16.4. And on the second question, which is over the page, for essentially the same reasons, the Court, in essence, repeats its analysis and refers back, but also refers to the conclusion in Ziolkowski, which we do have before the Court, but it's not necessary to go to it. The key point that comes out of it is here. It's at paragraph 30. Referring to a gradual system as regards the right of residence in the host member state. 31, the imposition of a prison sentence is such as to show non-compliance. That's effectively repeating earlier reasoning. And so it follows, at 32, they must be interpreted as meaning that continuity of residence is interrupted by periods of imprisonment.
So no to question 1 and yes to question 2.
That's right.
Just read 32, please. Paragraph 32.
32, yes, I thought I'd just got to that. 32 follows that the answer is must be interpreted as meaning that continuity of residence is interrupted by periods of imprisonment in the host member state of a third country national who is a family member of the union citizen who has acquired the right of permanent residence in that member state during those periods.
Is it a yes or is it a no to question 2?
The answer to question 2 is a person who's served a period permitted to aggregate. The answer is no.
I thought so.
Yeah.
So you can't add up
No.
periods before imprisonment and after imprisonment because you've got to achieve continuous 5 years.
Because that is,
The answer was yes to the question as you phrased it.
yes, that is why I've...
That's the point.
That is why...
Very well.
The question as you
corrected.
phrased it was, does imprisonment break the continuity for Article 16 purposes? Which the answer is yes.
I am guilty of reformulating the court's question.
Well, reformulating questions is the name of the game.
It is the name of the game. It is the name of the game. But there we are. That is the clear conclusion. And it is, again, just to note, at MS 896 to 897, that conclusion reflects the analysis of the Advocate General at 47 through to 50.
What was some of this gentleman's factual residence after April 2006?
Some of it was.
Some of it will have been, but not 5 years.
No.
Okay.
So the same analysis would have applied in his case, whether it was before or after 2006. The closest he came, and which he argued was enough in all the circumstances, is right from December 1999, when he married an Irish national. I think he managed 4 years and 9 or 10 months before his first prison sentence in September 2004.
Yep.
So it is, I mean, these rules of 5 years in Article 16 and 2 years in 16.4 are arbitrary cut-off times, but they are applied because they are taken as being the litmus test, if you like, the benchmark, for the requisite degree of integration or the requisite degree of loosening of the links of integration in the case of the 2 year period as being sufficient. And they are bright lines, as this case shows.
It's easy to... I'm sorry, after you.
I was going to say, any length of imprisonment, there's no hint of any... well, I suppose there's a de minimis principle, but nothing else.
I'm not sure it's a principle that the Court of Justice recognises, but there's no exploring of that. The Advocate General does...
If you're taken into custody, they haven't. This case doesn't deal with that situation.
No. The closest it comes is the Advocate General at paragraph 56, at the top of MS 897. makes clear, that in his view, contrary to the submission of my learned friend, that
It's still sentencing.
house arrest or part release, a scheme obliging the prisoner to return to prison in the evening. So an open prison with work is not possible to conclude.
Yes, but it might be different if he was simply on remand, mightn't it?
It might well
Supposing
be
he'd been on remand and then acquitted.
Yes, I would accept that might well be different because the very fact that he was acquitted would show he had not committed that act, which was in conflict with the values of society and hence would not have undermined the levels of integration.
Yeah.
So the fact that you're, on a hypothesis that the victim of an injustice or just held on remand without subsequently being convicted can't be taken as indicative of loosening your links with that society.
Mr. Palmer, I was simply going to observe that when all's said and done, we are dealing with enhanced protection rather than rights of permanent residence. And it just might be relevant at some stage to consider what the Advocate General said at 28 about this. Actually, it's the top of 894. The conditions for the grant and loss of the right of permanent residence must be distinguished from those relating to the loss of enhanced protection. Saccharidis is not relevant. So when you're dealing ultimately with the link between all this and enhanced protection, you might like to deal with that observation.
My Lord, I will. That's a necessary link in the chain of my argument.
Yes.
Before I deal expressly with that point, can I just deal with one further authority, which is MG at tab 13, which is MS 876. MG was handed down on the same date as on inquiry by the same second chamber of the Court of Justice, although they were heard shortly, separately, shortly before one another. And there is cross-reference in this decision to that in on inquiry. The facts can be taken at page 882, in paragraph 12. MG was a Portuguese national. She entered the UK in 1998, was employed, had children, and separated but remained married. And then paragraph 13, see, on the 27th of August 2009, she was convicted of count of cruelty and assault and sentenced to 21 months imprisonment. So at paragraph 19, we see that in this case, the Secretary of State accepted that Miss G had acquired a right of permanent residence and that she'd not subsequently lost that right. So this was not one of those transitional cases where, although fulfilling the conditions by 2003, she subsequently left or ceased to qualify or was imprisoned before 2006, but she was imprisoned for a period afterwards. And here, the straightforward question was whether Article 28.3a applied to her in a series of questions 1 to 4 set out at paragraph 21. The court dealt with questions 2 and 3 together, which asked whether the 10-year period for Article 28.3a purposes had to be continuous and whether you count back from the expulsion decision, as the text of 28.3a seems to say, or whether you count forward, a bit like you do for acquiring a right of permanent residence. The answer to that question was answered with reference to Saccharidis, which will come later, 24, 25, but then 26. And then the answer 27 is that the period of residence must be continuous. 28 must be calculated by counting back.
Well, it doesn't say continuous, does it?
It says 27 The period of residence referred to in that provision must in principle be continuous.
Yeah, in principle, because
is the phrase it uses.
And again in 28.
Again in
Same
28.
expression.
Yeah, same expression. Must in
And must be
principle
calculated by
continuous.
counting back.
That's not, as we'll see in a moment, that's not the end of the story, but that's the starting point. You're looking at that 10-year period, that continuous period of 10 years immediately before the expulsion decision. And then questions 1 and 4 were taken together, which we see at 29 were summarised as asking, in essence, whether a period of imprisonment is capable of interrupting the continuity of the period of residence for the purposes of that provision, and may, as a result, affect the decision regarding the grant of enhanced protection provided thereunder, even where they have resided in the host member state for the 10 years prior to imprisonment. So a different time period being referred to there, the 10 years prior to imprisonment. And the court answers that, first of all, at 30, again, recalling the important levels of integration in question. The greater the degree of integration, the greater the degree of protection we saw from the recitals. At 31, recalling on inquiry in the context of Article 16. 32, going on to say, since the degree of integration of the persons concerned is a vital consideration underpinning both the right of permanent residence and the system of protection against expulsion measures established by the directive, the reasons making it justifiable for periods of imprisonment not to be taken into consideration for the purposes of Article 16 and to be regarded as interrupting the continuity needed to acquire that right must also be borne in mind when interpreting 28.3a. And so at 33, it follows that periods of imprisonment can't be taken into account and that in principle, such periods interrupt the continuity of the period of residence for the purposes of that provision. And the 10-year period at 34 must in principle be continuous. So if one were to pause there and read no further, one would be looking at that period of 10 years before expulsion, answering the question, has this person resided in the host member state for the last 10 years? The answer would be, in principle, no, because the periods of imprisonment don't count and break continuity. The court continues at 35, as for the question of the extent to which the non-continuous nature of the period of residence during the 10 years preceding the decision to expel the person concerned prevents him from enjoying enhanced protection, an overall assessment must be made of that person's situation on each occasion at the precise time when the question of expulsion arises. And in that regard, given that in principle periods of imprisonment interrupt the continuity of periods of residence, such periods may, together with other relevant factors, be taken into account by the national authorities responsible for applying Article 28.3 of that directive as part of the overall assessment required for determining whether the integrating links previously forged with the host member state have been broken. At 37, they go on to consider as part of that, you can take into account the fact that the person concerned resided in the host member state during the 10 years prior to imprisonment, if he or she did. That would be a factor in that consideration. So in this context of a person who has acquired a right of permanent residence, but subsequently been imprisoned or has been imprisoned in the period of 10 years immediately before the expulsion decision, doesn't lead to the application of a bright line. You see different language being employed here, which require a full contextual assessment of whether or not the links previously forged, in particular those links sufficient to acquire a right of permanent residence, and links forged subsequent to that, have been broken. So that is the exercise that one is doing in that situation. I ask you to note at this stage that, again, the focus of attention is on the quality of those integrating links.
Does it come to this, that when you're asking whether there have been 10 years at all, you must exclude from consideration any period of imprisonment, but provided there have been 10 years, then it doesn't actually have to be literally continuous, because in principle it seems to mean something more like essentially.
Well, the most immediate answer to that
And
question
you may
is,
be able to also, it doesn't actually have to be immediately prior to the expulsion decision, because it can be prior to the imprisonment, according to paragraph 38.
well, as a factor. So my Lord, the immediate answer to my Lord's question is no. The period you focus on is literally the 10-year period prior to the expulsion of the expulsion decision, to begin with.
That's the prima facie position, yes.
Assuming if there were no imprisonment during that period, then no problem, Article 28.3a applies. If within that period there is a period of imprisonment, then one has to, as a matter of contextual analysis, decide, in effect, whether as a matter of fact and degree, taking into account all circumstances, whether the consequence of that interruption of continuity is that integrating links previously forged have now been broken. And one of the factors which will be relevant to that will be to the extent of prior residence, even before the imprisonment. Because if someone had 10 years even before imprisonment, then it can be assumed that their integrating links are stronger than a person who did not have 10 years even before imprisonment.
I think you're saying something different from what I was saying, therefore, because
Yes.
you're suggesting that if somebody had only been in the country for 10 years before the deportation order, then he might be entitled to the benefit of enhanced protection, even if during that 10 years he'd been in prison for a period. I was suggesting that it seems to be clear from, say, paragraph 33, or that when you're calculating the 10 years, you have to, on any view, exclude the period of imprisonment. Yeah. But that doesn't mean to say that you can't find 10 years of residence without imprisonment and treat that as sufficiently continuous and sufficiently precedent to the deportation, even if the imprisonment occurs at just before the deportation.
Lord,
you're disagreeing with that?
No, Lord, in terms of practical application, I wouldn't disagree with what my Lord has said, because if one thinks of imprisonment as weakening or loosening, to use that phrase, integrating links, as if you like, weighing in the debit column. Yeah. And if one thinks of lawful residence in compliance with EU law and exercise of treaty rights as weighing in the credit column, then someone who literally arrived just 10 years before the expulsion decision, but spent at least a significant period of imprisonment during that, would almost by definition not have the quality of residence overall that someone who had spent 10 blame-free years would have.
Well, I mean, I see.
But someone who had been here for an earlier period prior to imprisonment, who could invoke another period of 10 years, could put that in the credit column and might be able to say, well, that outweighs the debit of the imprisonment when you take an overall view. So if you've literally just got 10 years and within that you're imprisoned, it may well be that you fail on 28.3a.
Well, if you've got, let's forget about 2006 for the moment, it's easier for those of us who are struggling. If you've got 10 years since arrival, and shall we say year 6 was spent in prison, do you get to the overall assessment or do you not?
On the literal application of MG, assuming you have established your permanent right of residence in the first 5 years of that period,
yes,
then the answer is yes, you get to MG. But if you're convicted of
you get to intermediate protection on that.
You get to intermediate protection.
Follow that. But do you get to enhanced protection or not?
You get to be considered under the test in MG And on that particular hypothesis...
Even though you haven't done 10 years, because after all it's 9 years at liberty and 1 year in custody.
My formulation of that, my Lord, would be on the application of the MG test, the answer would be that you don't get Article 28(3)A.
Right.
Yeah.
But it doesn't mean, it isn't that you can't, it is that you won't.
It is that in its practical application, as I put it to my Lord of
Yes.
Mance, you won't.
So you do get to the overall assessment, so
I accept that is a matter on this authority.
It's incredibly
applying it as best-
confusing, isn't it? Isn't it confusing?
Applying
On
it
the
as
one
best I
hand,
can.
they give it to you, in principle it doesn't count and it breaks continuity, but on the other hand, they take it away by saying, then you've got to have an overall assessment of the level of integration. Yep.
Which is
It's
why...
completely different from Article 16.
Which is why, in its practical application, if you can't muster 10 years outside prison and then lawful exercise of EU rights, it would seem that on this logic, you can't succeed to continue to gain the protection of Article 28(3)A. That would seem to follow, but the court puts it the way the court puts it.
So are you conceding or alleging that this judgment is mutually inconsistent? Are you saying that 33 and, let's say, 36 are mutually inconsistent?
But, my Lord, I'm not...
Or how, if not, how do you marry them together?
My Lord, you marry them together by recognising that in principle, a period of imprisonment disrupts continuity, and it is then necessary to analyse the effect of the non-continuous nature of the period you have identified, to use the language of 35, to see on an overall assessment whether that person continues to enjoy Article 28(3)A protection. But that is only possible, that only makes sense if you conclude that if you can't muster 10 years outside prison, you won't make the grade in practice. Otherwise, it's very difficult to understand that logic.
If the continuity of the 10 years was absolutely crucial, then to say, well, prison, I'm afraid, interrupts it, you'd have thought that would be the end of the story. Mm-hmm. But is reliance being placed on the fact that 28(3)A doesn't actually use the word continuous, Mr. Palmer? Is that one way out of this
it's not
conundrum?
It's not a way out of it, unfortunately, my Lord. It's a way which tempted the referring tribunal in its question 3 by trying to invite the court to effectively rewrite Article 28(3)A to say a continuous period will do. But what the court responds is that you're simply looking at the time period, the 10-year period before the expulsion decision, which is looking to see what happened within that time period.
I find this difficult. I mean, I'm not sure at the moment that I agree with quite the way you're putting it. I feel that they may be identifying two different things. One is the question whether the period of imprisonment can count towards the 10 years, and then the other is whether it can interrupt the counting of time or the continuity of time when you're considering whether the 10 years, which you must establish apart from imprisonment, is sufficiently proximate to the and sufficiently continuous and sufficiently proximate to the deportation decision. And I mean, if you look at paragraphs 32 and 33, there are two halves to the question. The point. The reason of making it justifiable, 32 says, for periods of imprisonment not to be taken into consideration for the purposes of granting a right of permanent residence, or for such periods to be regarded as interrupting the continuity of the period of residence needed to acquire that right, must also be borne in mind. And then in the next one follows they can't be taken into account for the purposes of granting the enhanced protection provided in 28(3)A, and that in principle they interrupt the continuity. I think there's maybe two different things. And they then go on to the continuity point, but they've already said, and they've drawn the analogy of the 2-year absolute bright line break on new query in paragraph 31, they've already, in their minds, decided that imprisonment can't count as lawful or as a residence would build up the 10 years. You have to build it up separately. What they're concerned with here is the problem that the 10 years was prior to the imprisonment. If you look at paragraph 29, they use that phrase, and they use it twice in paragraph 37 and once in paragraph 38. And that's why they're focusing on the issue. They've got the 10 years under their belt apart from imprisonment, and they're focusing on the issue of continuity and proximity.
Yeah, I wonder if that doesn't have to be right, because otherwise you could end up qualifying for enhanced protection under 28.3, but not for the ordinary level of protection under 28.2, which would be an absurd result.
Well, yes, that is right. We do say that a consequence would be absurd. So, the very point I'm going to come to next, in fact. But to answer Lord Manser's point, I certainly accept that there is that distinction drawn, and it may be that it has the consequence which my Lord has suggested. What I point out is that because of the first half, the answer to questions 2 and 3, it's clear that the focus of attention is the 10-year period immediately before the expulsion decision. We then get to 33, where it's clear that any period of imprisonment within that, A, doesn't count, so therefore on the face of it, you'd say at that point you don't have 10 years residence, and B, breaks continuity. And as to B, we go on to consider the consequences of non-continuity, and it seems as part of that analysis, you bring back into consideration, paragraph 37, any previous period of of qualifying residence, a 10-year period residence, to consider the consequences of non-continuity. But, my Lord, I accept that one is struggling with a judgment which is not a model of clarity. But,
yeah.
but in practical terms, what we move to is a consideration where someone who can't point to 10 years of lawful residence without doing something serious enough to be imprisoned will not have the degree of integration required to enjoy the benefit of Article 28.3a, which, looking at the language of Article 28.3a, you would not at first blush detect, but nonetheless is the consequence.
I would take it from the absence of any opinion in this report from the Advocate General Vatelet that there was no opinion.
Yeah, the court proceeded without an opinion. The Advocate General was there.
Often when problems arise.
Yes, the court considered that it could dispense with an opinion as it had had an opinion in New Query, which was deciding...
The same character, same individuals in respect of each... playing a part in each of these decisions, so presumably they're thought to be the specialists.
It's the same juge rapporteur, Judge.
No, it's the same. Many of the same judges.
Yes, and the same
Judge
court.
Silver Orestes.
Yes,
They're all the same part.
the same juge rapporteur as in Diaz, in fact.
Yeah.
So that is MG, and I say you put it all together, and.
Isn't there some provision under the rules of court that you can only dispense with an Advocate General if the case doesn't raise a point of any particular importance?
Or new point, I think, and I think because the court felt it was deciding this in the same way as it was deciding on inquiry.
So working backwards from the absence of an Advocate General's opinion, we ought to be able to find that this in fact adds nothing to some previous decision, whether it's on inquiry or Zacharidis.
Zacharidis, yeah. Yes. Now, Zacharidis, which I'll come later, is explicitly dealing with the effects of absence from a member state, which is why you then get to the question, rather than the loosening of degrees of integration being the language, you're concerned there with whether the centre of a person's interests has transferred to another state, to another country, is the touchstone. But by analogy and comparison with Zacharidis, and in particular Zacharidis at 25 to 26, which will come later, to absence and imprisonment are taken as weakening links. But put all that together, and in particular the fact that imprisonment weakens integrating links, and the answer is that so far as the transitional point is concerned, once you've got 5 years in the bag, but then there's a period of 2 years before 2006, absence, see LaSalle, non-qualifying residence, see Diaz, and imprisonment, see Onique and MG, all have a similar effect of loosening integrative links. And so when one applies 16.4 by analogy in each of those cases, the result is the non-acquisition of the right of permanent residence on the 30th of April 2006. It doesn't prevent you from acquiring that right subsequently if you restart the clock and subsequently fulfill 5 years continuous legal residence, of course. But the result is, on that date, you have no right of permanent residence. It follows from that if you are in that position, as we say FV clearly was, having spent up to 5 years in prison before 2006, you do not enjoy the benefit of the protection of Article 28.2. It's just on the straightforward application of the language of Article 28.2 itself. And we say it follows clearly and logically from that proposition that you do not enjoy the enhanced level of protection under Article 28.3a either. Now, there has been previous domestic authority on that point. It's an Authorities Volume 1, at tab 5.
But there's no Luxembourg authority.
There's no Luxembourg authority on well, there's some dicta, which I'll refer to in a moment. Which make it, as I say, implicit in this logic of integration, and indeed in the recitals, to which I'll refer in a moment.
We follow the logic completely, but that doesn't mean to say that it's right.
I'm going to attempt to persuade you it is right for the reasons that the Court of Appeal has given when considering this very question. It's an MS 667.
Do we feel a reference coming on?
Not on this question of the position in relation to pre-April 2006.
Oh, no, it's the 28.3a.
Yeah, no, but as part of that, I say that that's already sufficiently clear. I accept that the position in respect of the effect of imprisonment on an acquired right of permanent residence, when someone actually does have such a right, and then one is considering the effects of imprisonment on the loss of that right, as seemed to be indicated could happen in Diaz, is arguable and less clear at the moment. But it's my principal submission to the court today that in a transitional case, where someone has not acquired a right of permanent residence, they cannot not only enjoy the benefit of 28.2, but also 28.3a. In that context, can I take you to the decision of Court of Appeal in HR Portugal, which is at page 667, MS 667. And the first thing to point out is the court will note from the date of the judgment, May the 5th, 2009, that this predates all of the Court of Justice authorities to which I've taken the court. So they didn't have the guidance that we've been through. Nonetheless, the analysis which they conducted is, in my submission, consistent with what subsequently emerged, and on the central assumptions made in this case have since subsequently been borne out by Court of Justice jurisprudence. The issue that the court was considering in this case is expressed at paragraph 1 in the judgment of Lord Justice Stanley Burnton, MS 669, the final 5 lines. Paragraphs. Mm-hmm. So that was the issue at paragraphs 3 to 4, there's a somewhat messy situation on the facts because the outcome of the consideration by the tribunal below was considered paragraph 4. The tribunal considered he had acquired a permanent right of residence under Regulation 15 and therefore had the benefit of Article 28(2). But in fact, as will appear from the court's analysis of the facts, because rightly, as it turned out in on inquiry, they said that time in prison didn't count towards the acquisition of a permanent right of residence, the Court of Appeal proceeded on the basis, the correct basis, in fact, that he did not, HR did not have a permanent right of residence. So in fact, on analysis, this is a case like FV, where no right of residence had been acquired on the 30th of April 2006. Paragraph 20 of Lord Justice Stanley Bennington's judgment, which is page 675, the judge recited the recitals. They are not numbered in this printout. They are respectively 9, 23, and 24, which we looked at earlier. And then the significance of those recitals is analysed from paragraph 21. I respectfully submit the reasoning is correct. It continues over the page at 22 to 23. And then the judgment of Lord Justice Elias, he noted at paragraph 31 that it was conceded that the period actually spent in prison would not count when determining whether the appellant had resided legally for the continuous period of 5 years necessary to constitute permanent residence within the meaning of Article 16. We now know from an inquiry that that concession was rightly given.
As a matter of, you haven't referred to it, but as a matter of interest, Chapter 6 in the directive is actually headed on MS 542, restrictions on the right of entry and the right of residence on grounds of public policy, public security or public health. So that governs Article 28. Does it follow from that that it would be quite logical to assume that Article 28(3) is dealing with a situation where a person has resided with some right for the previous 10 years?
Well, yes. Well, yes, it's not a question. If someone's is an illegal entrant is hiding in a remote cottage for 10 years and is then discovered, he cannot claim Article 28.
Yes, I mean, so that's the logic of the progression argument that.
But it still begs the question of what sort of right of residence? Because you could have a simple right of residence rather than a right of permanent residence.
Yes. Yes, I suppose that's right. If your residence doesn't...
It is true that you can have a simple right of residence rather than a permanent right. What the directive makes clear through its recitals, and the case law of the Court of Justice makes clear through its emphasis on the references to integration within those recitals, is that acquiring the right of permanent residence is a benchmark, a litmus test for the achievement of a certain degree, a qualitative degree of integration, which tracks the protection for that reason in 28(2). That's what comes out of recital 24, the greater the degree of integration, the greater degree of protection. So the greater protection of 28.2 reflects the greater degree of integration, which is attached to the permanent right of residence. And then a still greater degree of protection reflects a still greater degree of integration for someone who's not only has a permanent right to reside, but has been here been in the host member state for 10 years, residing in exercise of that right. So that escalator of qualitative deepening of integration attracts increasingly greater protection to reflect that level of integration in exercise, as Article 23 puts it, or having availed themselves of the rights and freedoms conferred on them by the treaty. That is the key point. And Lord Justice Elias returns to this at paragraphs 35 to 36. Again, consistent with this being an escalator of protection, each step following on from the last. There was some subsequent consideration of this case in two further domestic...
Just before we leave it, paragraph 44, Lord Justice Sedley says that Council for the Home Secretary was able to put before us information about the differing meanings attributed by a number of national courts to the material provisions of a directive. Is post-MG, are you aware of any case law from other national courts that might be of assistance, or indeed it indicates a different approach from the one that you're arguing for?
My Lords, we're not. That analysis of other courts' approach to directives came, obviously, in the absence of guidance from the Court of Justice. Now that we have that guidance...
such as it is.
Such as it is. We took the view that is what had to be,
right.
Had to be interpreted. It's unlikely that another national court's particular practice would cast light on the Court of Justice's...
No, but it might be relevant in deciding whether to make a preliminary reference.
On this point.
Yes. Well, certainly if that became decisive or could be decisive to the court's consideration, then I could seek instructions and provide what details are available to the Secretary of State. But we have not done that exercise yet.
But if the focus of a right of permanent residence is really a threshold to the ability to claim public benefits, why should the issue as to whether somebody is entitled to claim public benefits really inform the circumstances in which he is able to be deported?
Well, I don't accept that premise that one reduces the right of permanent residence simply to eligibility to claim benefits. There are some benefits under the domestic law of the United Kingdom which are linked to having a right to reside, and amongst the means of establishing a right to reside are the means of demonstration that you have the permanent right of residence. It is true that under the directive, the structure of the qualifying rights under Article 7 are in part linked to self-sufficiency, for example, for students, for self-sufficient people who have comprehensive health insurance and so forth. And once they get to the stage of 5 years and have a right of permanent residence, they no longer have to fulfill those conditions. But some benefits are available nonetheless all the way through. The litmus test under Article 14 of the directive as to the retaining the right to reside before you get to the 5-year stage is simply that you're not becoming an unreasonable burden on social assistance. It's not a bar on claiming any social assistance at all. So the precise arrangements in each member state will vary. The right of permanent residence does have some consequences for social assistance, social security, but it's not right to reduce the right of permanent residence solely to that issue of eligibility for those benefits. It is a qualitative right which, more than anything else, frees, because of the level of integration, frees the individual concerned from the obligation to fulfill any of the conditions of Article 7, such as being a worker, as a matter of status, a self-employed person, a student or self-sufficient, or indeed even a family member.
If an EU citizen doesn't qualify under Article 7 and the associated articles and simply arrives, doesn't work, isn't a family member, so on, can they be, apart from after the first 3 months, can they simply be removed?
Yes, they can.
Without a proportionality exercise?
The initial right to reside they have for the first 3 months.
3 months, yes.
After that, their continued right to reside is entirely dependent on whether they can qualify. You have marginal concept. You have, for example, you can be a worker even though you're not at that time employed, for example, because you're active job seeker and so forth. So there's shades of grey around the margins applying the test. But if you're not, at the end of the day, qualifying, you can be removed because you have no right of residence. So the protection in Article 27 and so forth, Article 28, doesn't apply to you because there is no interference with a right of residence in those cases.
If that's right, then the consequences are well beyond eligibility for benefits. I mean, it tends to crop up in the context of eligibility for benefits, but if that's right, it goes well beyond that.
Yes.
I see.
So it's the benchmark of deepening integration. If you have been here for 10 years and been here in lawful exercise of your rights, then you will have a right of permanent residence. If you have not yet established even that lower threshold of protection, we say it's simply bizarre and absurd to suggest that you should be granted the highest level of protection, which is intended for those individuals who have not only got the lower level of protection, but have remained here for as much time again as it takes to acquire that permanent right of residence in the first place. And let's move on in the time that remains to me, just to point out there are two subsequent domestic authorities considering this point as well. They can be dealt with shortly. The first is at tab 6 at page 680, which is a tribunal decision over which Lord Justice Conrath, as he then was, presided as senior president of tribunals. And I simply point up at this purpose that for this purpose is at page 691. He says at paragraph 42, after considering HR Portugal, that the ratio of the decision is that in respect of the quality of residence, no distinction is to be drawn between the 5-year and 10-year periods, notwithstanding the absence from the latter of an express reference to the need for it to be legal. That accords with the view we had reached before seeing the judgments. And then when CC's case, one of the two appellants before Lord Justice Conrath on that occasion, when his case reached the Court of Appeal, it was referred to as Cesar C. or Carvalho. That's at tab 7, page 718. And at page 723, Lord Justice Morris Kay concluded at paragraph 14, the tribunal's consideration of that case, 6 or 7 lines down, concluded rightly, in my view, that the ratio of HR Portugal was narrow, being confined to the decision that in respect of the quality of residence, no distinction is to be drawn between the 5-year and the 10-year periods. Those dicta are consistent, in my submission, not only with MG, you'll note at 32, I won't turn it up again now, but also with the last remaining authority of substance before the court, which I haven't yet been to, which is Saccharidis. Saccharidis is in volume 2 at tab 9 from page 766. And for this point, I'll just go straight to paragraph 32 before I fully introduce the case. Paragraph 24.
And that's on page?
I beg your pardon, Melody, it's page 791.
Thank you.
Again, in the context of the consideration of entitlements to the benefit of Article 28.3a, again, the court put specific emphasis on recitals 23 and 24, and the level of integration matching the degree of protection. And in the following paragraphs, contrasts or shows how the levels of protection build up. First of all, 27 under 28.2, recording position under 28 under 28.3, which considerably strengthens their protection against expulsion. And then going on to considering the circumstances which can interrupt that. So the integration-based analysis conducted in HR and subsequently in LG and CC and Carvalho is the correct one, as made clear in Saccharidis. Now, my learned friends for FV heavily rely upon Saccharidis, saying it is the Secretary of State's undoing, effectively. We say it has no effect of the kind claimed for it by Mr. Hussain. Taking a look at the facts, page 788. The starting point is that Mr. Saccharidis, who is a Greek national, was born in Germany. So he was in the classic case, which we know from recital 24, is worthy of most protection when someone is born in another member state and lives all their life there, including their childhood. So born in 78, in 96 he left school. He had an unlimited residence permit in Germany from October 2001. And then still pre-2006, he went for 6 months in 2004 to run a pancake stall on the island of Rhodes in Greece. Pausing there, we know from LaSalle that absence won't be fatal, just 6 months long. He then returned to Germany where he worked again, and then in mid-October 2005 he went to Rhodes, resumed running his pancake stall, and on November the 22nd, 2005, the local court, the Amtsgericht Stuttgart, issued an international arrest warrant against him, with the result that on November the 19th, 2006, so we're now for the first time post 30th of April, he was arrested on Rhodes and transferred to Germany on March the 19th, 2007. I'll just pausing there just to draw out from that chronology an important point. When the magic date of the 30th of April 2006 arrived, he had been absent from Germany only since mid-October 2005, so about 6 months before. So again, a short absence at that date.
Plus the 6 months in 2004.
Well, one doesn't aggregate those two periods. He went for 6 months, came back, no problem there. He continued to work in Germany. Then he went away again. 6 months after he went away again, the date arrived. And even when he returned to Germany on March the 19th, 2007, we're still less than 2 years since he had departed in October 2005. So there's no doubt whether on the 30th of April 2006 or if the right test is when he actually returned to Germany and re-exercised his right to reside, he had at that point of return a permanent right of residence.
Well,
crystallised.
He didn't return to exercise his right to reside, did he? He came back because he was arrested.
He was arrested and compulsorily returned, but nonetheless he was physically present.
In any event, he hadn't done 2 years, as you say. Yeah.
Certainly, if he had returned voluntarily at that date, there'd be no issue. He had a permanent right of residence. It could be argued otherwise. If he was returned and then subsequently acquitted, of course, he would have been told, do you have a permanent right to reside? My submission is that having returned, having not been away for more than 2 years at that point of return, there's nothing to suggest that he had lost his permanent right of residence, and indeed he was treated as having that, as you can see at the paragraph of bottom of paragraph 19 on page 789, where the local court, the Verwaltungsgericht Stuttgart, observed that he had not lost his right of permanent residence as a result of his stays on roads. So he was certainly treated by the national court as having that right, and the questions which were asked on that basis, that he did have that right. It is true, my learned friend points out, that if you aggregate the amount of time he was away on roads from the second time he went, from October 2005, with the time he spent in custody in Germany, having been returned, tried, sentenced, and served a term of imprisonment in Germany, if you aggregate all of that, you get to over a period greater than 2 years. My friend's point is, look, they didn't suggest he didn't have permanent right of residence. They didn't suggest he didn't have automatically didn't have Article 28.3a protection. The answer to that is, this was not one of those early transitional cases, or to the extent that it was, it crystallised that right before the 2 years had expired, or at least, for good reason or bad, it was certainly treated as having crystallised by the domestic court, and the questions were asked on that basis. So when we come to the questions, the question was, having been spent time in prison, could he claim the protection of 28? Sorry, having spent time absent was the focus of the questions from Germany. Could he still claim the protection of 28.3a? Now, it's important in that context to understand the animus behind the court's question and behind the court's, including the Advocate General's, consideration of that question. You can see at paragraph 21, at question 2, the question was put, under what conditions can the right to enhanced protection against expulsion achieved following 10 years residence subsequently be lost? Is the condition for the loss of right of permanent residence laid down in Article 16.4 of the directive to be applied mutatis mutandis in that context? And the way in which that question was considered and applied, bearing in mind that the period of absence concerned was one of 16 months, was treating that question as being, does Article 16.4 lay down a minimum period of 2 years before there can be a loss of rights? Or can there be circumstances when a shorter period will suffice? Now, you see that very clearly from the Advocate General's analysis on page 783. Paragraphs 117 to 119, just setting the scene there with the different levels of protection, degrees of interpretation, and 119, it seems to me therefore be a link between the level of integration to that state and the level of protection afforded. And then at 124, I consider that an absence of more than 16 months, such as that in the present case, may cause the loss of the enhanced protection granted under Article 28.3a, and that therefore it is not possible to apply mutatis mutandis Article 16.4 of the directive. In other words, we are not here applying a 2-year minimum, which applying mutatis mutandis Article 16.4 would imply. You can lose this right. You may lose this right on the basis of 16 months' absence. We see that analysis continued at 126, just noting that his first absence was short and didn't didn't matter. But at 128, in contrast, his second absence, 16 months, which was interrupted not of his own accord, but because he was subject to an enforced return, interrupted the 10-year period. I consider that such an absence shows in actual fact that the Union citizen established himself in another member state, and that therefore the link between him and the host member state is no longer as strong and may even be totally broken. So he's not there aggregating the period of imprisonment in Germany. He's looking at the loss of the link by reason of establishing himself in another member state for a period of 16 months. In light of the foregoing, he says at 129, he considers it unlikely that Mr. Saccharides may rely on the right to enhanced protection provided for in Article 28(3)(a), and 131 to 132. As a general rule, temporary absences do not undermine, but on the other hand, an absence of more than 16 months, which, as in the present case, ended only in enforced return, is likely to cause that citizen to lose that right. So that's what the Advocate General thought. That is why he gave the answer no to the question, do you apply 16(4? Because you can lose that right with a shorter period, depending on the facts. Now, returning to what the court makes of it, at paragraph 22, first of all, on page 790, recasts the question as one there. 24 to 25, emphasis the integration, so forth. Then at 30 to 31, what it is doing here again is rejecting the suggestion that Article 16(4) applies a minimum threshold of 2 years' absence before you can lose the right. So at 30, it refers to the court's consideration that it may be possible to apply by analogy the criteria in Article 16(4). And it does answer that question ultimately, no, you don't by analogy, but only in the context of, as appears from subsequent analysis, a shorter period could do. That's why at 31 it emphasises that the decisive criterion is whether the Union citizen has lived in that member state for the 10 years preceding the expulsion decision, because it is going on to consider whether, in fact, on analysis of the facts, Mr. Saccharides had changed the place where he lived to Rhodes in October 2005, and so no longer could be said to live in Germany. Obviously, there's degrees about temporary absences, about whether you still say, oh, I live in Germany, but I'm here for a while, I'll be returning back to Germany soon, or whether you transfer yourself to a new centre and sort of begin your life and say, well, I now live in Rhodes again. That's a fact-sensitive judgment which will vary from case to case rather than the application of a bright line. But that is the significance of what it says being the decisive criterion. You have to make a judgment about where that individual now lives. Does he still live in the member state, in the host member state, and has he lived there for 10 years? So at 33 to 34, you find that test of how that fact-sensitive judgment in each case should be made. And then at 35, it's for the national court to assess whether that's the case in the main proceedings, and then considers, on the basis of 16 months' absence, without adopting the Advocate General's suggestion of saying, well, 16 months is unlikely, it says it's a matter for the national court, but it considers either outcome as apparently equally possible, depending on what the national court concludes on those facts. So that at 37, if it were concluded that the person in his situation who has acquired a right of permanent residence in the host member state does not satisfy the residence condition laid down in Article 28(3), an expulsion measure could be an appropriate case be justified according to the 28(2) case test, because we know that he had or was treated as having that right of permanent residence.
It doesn't say so, but presumably the reason he went to Rhodes was that they were after him for the narcotics offences which he was convicted of when they extradited him or
We
got him
don't
back.
know whether at that time they were actually after him, but he clearly had committed those offences by that date, and clearly, for whatever reason, thought he was better off in Rhodes. But when they got onto
ironic,
him, we don't know.
having decided to flee,
Well,
then when you're brought back under an arrest warrant claim.
So there we are. So my own friend Mr. Hussain, with respect, looks at this from the wrong end of the telescope. When he says, look, you don't apply the 2-year test, that is because less will do. When you do have 2 years, the inference is all the stronger, given that a period of 2 years' absence, we know from 16.4, does destroy a right of permanent residence. And falling with it in those circumstances must be the protection conferred by Article 28(3)(a) as well, because you could no longer say, after 2 years, that you any longer live in the host member state. But apart from anything else, you've lost your right of residence there.
This is the source, is it, of the expression overall assessment, which crops up in MG.
This is then at MG, but the difference in MG is that they say, look, you shouldn't, in the context of imprisonment, be concerned whether there's been a transfer to another state of the centre of the personal, family, or occupational interest of the person concerned. That makes no sense in the context of imprisonment. You're not going to be transferred to another country by virtue of being in Women's Scrubs. But you are going to lose your integrative link with the country over time in a comparative way. Comparable way.
But, I mean, reading MG in the light of Zacharias, are they not expecting the National Court to carry out a similar overall assessment of the significance of the period of imprisonment?
That is right, my lord. That is why they think they're not deciding anything new. They're just drawing the parallel. But it brings with it its own complications, which I won't revisit. What I say is, when you look at it from that point of view, a period of over 2 years being the litmus test for that loss of integration, such that you no longer have your permanent right of residence if absent for that period, can equally be applied by analogy in the context here of the effect of a period of more than 2 years imprisonment. My learned friend says Zacharias says no, but in neither Zacharias nor in MG was the court concerned with a period of imprisonment of more than 2 years. In each case, it was dealing with a shorter period.
So, Mr. Palmer, I appreciate your time actually is almost up.
It is up.
It is up.
So can I just ask very quickly, if you're quite wrong about the need for RPR in the analysis of a claim for 10 years, do you have an independent point about the 10-year period claimed by this respondent?
My lord, yes, the independent point is this. The Court of Appeal, like the tribunal below it, did not conduct the exercise of the application of the MG test, unsurprisingly, because it predated MG.
Yes, quite.
So that exercise simply has not been done. So if a right of permanent residence is not required, then FV was entitled or had to have that exercise done. It is dismissed in wild terms, or sweeping terms, I should say, by Lord Justice Aikins, who says, I can't possibly see how a period of 4 years, in fact it's 5, could undermine the
As
links.
Lord Justice Pill had also said.
As Lord Justice Pill had also said, to similar effect. But in a context where they are expressly not identifying imprisonment as being capable of destroying those links by reason of a undermining of the links of integration, even after a period of 16 months. Look at Zacharias, someone who was born in Germany, lived his entire life up to 2005 in Germany, and 16 months was capable, for the National Court to the side, but capable of destroying those links. Now, in that context, you can't simply make such a sweeping judgment as was made by the Court of Appeal in advance of seeing the outcome of.
I thought you were making that point, but I wanted it clarified.
I'm very grateful. Miles, I'm after time, but those are my essential submissions, I'm glad to say. I'm very grateful.
Thank you very much, Mr. Farmer. Mr. Last?
I have nothing to add.
Mr. Hussain?
My lords, my lady, may I, before I commence my submissions, seek an indulgence and just ask you if I can have a 2-minute comfort break?
What a good idea. Yes, of course. We'll rise for a couple of minutes.
Thank you very much.
Yes, Mr. Hussain.
My lords, my lady, thank you very much. I'm very sorry for the inconvenience.
I don't think it was inconvenient at all.
My lord, my lady, I'm grateful. My lady, on behalf of Mr. Vomero, I wish to advance 4 submissions, which are summarised in our printed case at paragraph 11, MS 129 to 130. Those 4 submissions are, firstly, that the Court of Appeal committed no error of law in concluding that on the Saccharidis overall assessment, Mr. Vomero's ties with the UK weren't broken by his 4-year term of imprisonment from 2002 to 2006 so as to disqualify him from enhanced protection under Article 28.3a. Secondly, contrary to the key central theme in the Secretary of State's case, and I will of course deal with this because clearly it finds favour with certain of my lords, retention of the right of permanent residence is, while relevant, is not a necessary precondition for entitlement to enhanced protection. And if that is correct, then the Secretary of State's case essentially falls away, though I note my learned friend's point in reply to Lord Wilson, which isn't, we note parenthetically, contained in his printed case. But this is not, RPR is not a necessary precondition for reasons of language, precedent, principle, consequences, academic support, child development. Thirdly, we say that RPR is not automatically lost. It may be lost. It's not automatically lost on service of a prison sentence in excess of 2 years. And fourthly, the fallback position that even applying a proportionality test, given the amount of time that's passed, the number of tribunals that he's been through, Mr. Vomero's deportation, we say, is not proportionate.
Sorry, the third one was not automatically lost by a service of imprisonment.
In excess of 2 years, RPR is not lost. We say...
Right. No, I've got it.
We say that the language of Dias in a loss case, and Dias is virtual acquisition, but true loss, if I can put it like that. Onoquere, the key point about Onoquere is he's never had 5 years. So it's not virtual acquisition. It makes all the difference in the world. The paragraph I wanted my learned friend to read out at the end referred to 16.3. 16.3 is about acquisition. So we say that the language of the loss cases is not the language of a bright line rule. It's not the language of automaticity. But before I develop my submissions, can I just make 2 points? My Lord Reid asked a question about the interrelationship between the regulations and the directive. We have agreed that it's the directive that needs to be looked at because that is controlling. That's why we don't take a point on the language of residence.
It permits greater protection to be given by domestic law.
My Lord, I follow that. We haven't taken the point, but there are 2 respects in which the regulation cuts down. We respectfully submit, and I can just give you the references there. The first is, and this is, it picks up on a point that my Lord Wilson made, and this is at MS 587, Volume 1, Tab 3. This is in relation to continuity. My Lord Wilson said, is the answer to the MG conundrum the point that Article 28.3a uses the word previous, but not continuous. You'll see the regulation at Regulation 21.4a uses the term continuous. 21.4a uses the term continuous. We say that has to be modified in the light of MG. And the second point where we say the regulation cuts down on the protection granted by the directive and the case law of the ECJ is in relation to transitional provision. And you have that at 616. And this is Schedule 4, beginning at 613, transitional provisions. Paragraph 6, beginning at 616. 6.4 at 617, where the regulation states any period during which P, the person, carried out activity or was resident in the UK in accordance with the conditions, will not be regarded as a period during which P carried out that activity or was resident, where it was followed by a period, then B, which exceeded 2 consecutive years, for the duration of which P's residence in the UK wasn't in accordance with those conditions. And we take issue with the term will not. We say that is too categorical. It relates to the third point, my third submission, that there is no automaticity of loss.
One has some sympathy for the
Yes.
drafter of 80 pages of regulations, which I suppose are used by someone, but they're certainly not referred to when it gets to court.
By either side, my lord.
Yeah, I mean, it's a well, there we are. It's a function of where we are, but it is a rather amazing situation where, in truth, we all apply the directive.
Well, I think subject to my lord's point.
Well, subject, of course, subject
Subject to gold plating.
if someone had discovered a piece of gold plate, we'd be looking at it like anything, but whether it would have been intended to be gold plate would have been the question. Anyway, there we are, nothing to do with you.
Yeah.
You could write to the person who drafted the regulations and
Express sympathy. Well, it's more a point on the way in which European law is integrated in domestic law
Indeed.
than anything else. It's not the fault of the Home Office.
Indeed. And then the second sweep-up point I wanted to make is in relation to the issue of when RPR exists. Of course, it only exists as of the 30th of April 2006, and the references in Lord Justice Aikins, and indeed in our printed case, are to be taken as shorthand. What we were getting at, and what I was respectfully submit Lord Justice Aikins was getting at, when he said he had RPR by 2002, is shorthand for the proposition that there were 5 years legal residence at that point had been accrued. So, my lords, of course you can't enjoy the right before 2006. It doesn't exist. But for the purposes of analysis, or as my lady put it, you have it in a virtual sense if you've accrued 5 years.
Well, you've got a potential right, haven't you?
Everything else being equal, you have it.
Yeah. Well, and you've got one which will come into existence on the 30th of April 2006, yes, unless something happens in the meantime to take it away.
Ceteris paribus, you have it.
Yeah.
But that is it's important to not regard transitional cases as all about acquisition. They're not all about acquisition just because it doesn't exist until the 30th of April. My learned friend himself said that in LaSalle, the reason why 16.3 was regarded as irrelevant, that was the court's phrase, was because you'd already accrued it. You'd got the 5 years. On Aquare is completely different because he's never had it. It's a theme I'll come back to. Can I then develop my first submission, which is that the Court of Appeal committed no error of law in concluding that Mr. Vomero was entitled to enhanced protection and notwithstanding anything in MG. That is the central issue in the case. This case is not about RPR, it's about enhanced protection.
Did the Court of Appeal carry out, or has anybody carried out, the sort of overall assessment that Zacharidis and MG call for?
Oh, absolutely. I'll take you straight away to the relevant paragraphs, if that's helpful. It's Lord Justice Pill. I'm working from the Weekly Law Reports version. I don't know if that would assist, but I can give you paragraph numbers nevertheless. It's Lord Justice Pill at paragraph 85, and the MS number is 990 to 991. So what the Court of Appeal did is precisely to carry out the overall assessment required by Zacharidis. That is the central authority in the case. It's a Grand Chamber authority. My learned friend devotes little time to it for understandable forensic reasons. It doesn't help him. And we'll come to MG in a moment. But looking at the Court of Appeal, you'll see, my lord and my lady, paragraph 85, the question whether the requirement of a continuous period of 10 years residence established at the date of decision to deport turns on the degree of integration established at that time. This is a question of fact for the tribunal. Following the test in Zacharidis' case, periods of absence within the 10 years immediately preceding the decision don't of themselves disqualify, and neither does a period of imprisonment. That's completely consistent with MG. The period of imprisonment is, however, relevant as a factor to be considered when deciding upon the integration at the date of decision. Integration won't normally be established by time spent in prison. We say that is a correct reading of MG, in fact, or it predicts accurately what MG says, save that it may have limited relevance by contributing to the severance of links with the home country. If integration has been established prior to the custodial term, it won't necessarily be lost by it. And then the factors to be considered are set out by the Grand Chamber in the two cases, that's Zacharidis and another case called I. In I's case, 2 years and 4 months in prison before the decision was made didn't of itself defeat integration. We'll look at that in due course. But then, friends, right to say they didn't look at the question of RPR, but it's an important feature of the case that you had 2 years plus imprisonment, no suggestion that 28.3a didn't apply. The decision turns on an overall qualitative assessment having regard to all relevant factors, including length of residence, family connections, any interruptions.
Well, I can see why you say that 85 states, as it were, the question as posed by MG, but where is it answered?
It would have to be an actual consideration, an examination of the facts, applying these general principles to them.
You got a conclusion at 97.
Yes.
Do we go straight there?
My lord, yes. It's more. It's clearer in Lord Justice Aikins, if I may say so.
Well, he agrees with the Lord Justice Pill, and it's perfectly clear. I think you're talking about 127 in Lord Justice
Indeed,
Aikins. It's perfectly clear he's referring back to 97. So, I mean, on this part of your case, yes. I think you've got to hang it on 97 plus 127, Mr. Hussain.
Yes, and Lord Justice Aikins is the majority, because Lady Justice Rafferty agrees.
Yes, very well.
Mm-hmm. All that tells us that he's lived in the country, he's been present here for 27 years, for 14 of which he was the husband of a UK citizen, and he has children here. Well, it's not a very in-depth analysis.
Lord Justice Aikins, in the majority judgment, is much fuller, if I may say so, with respect to Lord Justice Pill. And you have that. It's not just 127, my lord. The relevant passages begin at the middle of 124 through to 127, and the 2 pages there, MS 1000 and then 1001.
Well, 127 contains an error of law, doesn't it? Because it's based on a premise that we must assume that FV had a right to PIR before he was imprisoned and was then indicated in the UK as a result of that.
No, not at all.
Well, it says, to my mind, if, as we must assume, FV had a right to PRR before he was imprisoned, he was then integrated in the UK.
Yes, what he's saying, if there is an error of law there, and I can see why my learned friend would say that, it's immaterial, because that is shorthand for the proposition that it must be assumed that he had 5 years of legal residence by that time, and the Secretary of State could not gainsay that.
It doesn't help him, does it? Because until 2006, the 5 years is of no significance at all.
Well, I don't accept that, my lord. We see from LaSalle and Dias, on the one hand, on Aquaria on the other, that when you're looking at a pre-April 2006 period, where you've accrued 5 years.
Well, it gives you a right as at the 30th of April 2006, but not before that.
Absolutely, my lord. But the test for when you will, whether you lose that right, that hasn't yet crystallised, we're in a virtual world, is by analogy with 16.4.
It's not virtual at all.
And the critical time period is 2 years. And we say there's no automaticity there.
Mm-hmm. But to Mr. Hussain, looking at 127, 5 lines down,
yes.
The crucial sentence, surely,
yes.
from your point of view, is, on the facts of this case, I fail to see how a period of 4 years in prison could lead to a conclusion that your client's existing integrating links had thereby been broken. Well, we know, actually, you don't just focus on prison. You focus on the reason why he's in prison. And you weigh the fact that the offence may by itself suggest a failure to integrate with the way we want things done in this country. So, but apart from that, can you associate yourself with the Lord Justice Aikins saying he fails to see how it could lead to a conclusion about the breaking of integrating links?
Because he is saying that the man has been here since 1985. He's had 5 children here. He was married with a British citizen who was working as a teacher until 1998. And that
apparently has nothing to do with his children, or his children don't have anything to do with him. And he's separated from his wife.
Yes.
And so on. My lord's focused on the sentence after the one I did. It seemed to me that the sentence that I was focused on is the reason for saying he was integrated, or a reason for saying he was integrated. So it does slightly undermine perhaps the next sentence that my lord was focusing on, with its reference to existing integrating links.
Well,
I mean, you would say that it's clear that none of this would have made any difference.
It's materiality. I think I'm bound to accept that MG makes it clear that imprisonment of itself can effect a diminution in integrative links. Of course I accept that.
I mean, there's so many references to overall assessment. Well, this is thin gruel in relation to that, isn't it, Mr. Hussain?
Well,
the person to do the overall assessment is the tribunal judge. And here's the Court of Appeal saying there's absolutely no point. It's all open and shut. It's very difficult.
Well, it's open and shut if you're in the threshold, whether the threshold's met or not. And that's not an issue. It's whether or not the threshold's met. That is open and shut, and it's not an issue. If this applies, the threshold isn't met on these facts because you need extreme circumstances. But
can I ask if it did go back to a tribunal now, would they be entitled to take into account subsequent offending and a relatively short 4-month, 16-week period of imprisonment?
They would, yes, because it would be...
They'd have to make a reassessment now as to whether he was integrated now.
Yes, 8 years after they allowed his...
Yes.
But I wanted to take you, I was going to take you to paragraph 124 across the page, where after the reference to Sakaridis, Lord Justice Aikins says the latter ruling indicates that a period in prison during 10 years immediately prior to the decision doesn't automatically mean that the national must lose his enhanced protection. All factors have to be taken into account. And the touchstone is whether there's been a transfer to another state of the centre of personal or occupational interest, or the integrating links previously forged with the member state have been broken. I accept that the notion of a transfer isn't meaningful in the context of imprisonment. The key concept is the breakage of integrative links, and that is what he's looking at. And that when he's saying, look, 4 years won't break them, I accept you need to take into account the nature of the offending which gave rise to the sentence and also the fact of the sentence itself. But the context here is a context of very considerable previous residence, and the point of the assumption, and I can make it good if you wish. This is not a windfall that he got, because there is a very powerful Surinder Singh point here. He met his girlfriend, to be his wife, in 1983 in Nice, when she was working as a chambermaid. They came back in 1985. So there's a clear Surinder Singh basis for his stay from 1985, irrespective of economic activity. And after the divorce in 1998, there is clear provision for the retention of the right of residence in the directive. We haven't gone to that because it's only of marginal relevance, but it's Article 14, which says post-divorce, Article 13, which says post-divorce, you retain your right of residence, and in some circumstances you can even get RPR. So that's not a windfall that he got because the Secretary of State didn't get her act together and argue the point in 2007 to 2008. But it's the substance of what Lord Justice Aikins is saying when he says there was an RPR in 2002 is that there was at that time accrued 5 years of lawful residence in compliance with EU law. That's how I would put it. And what he says at 1001 letter B is that if the matter were to be remitted to the tribunal, if the tribunal applies the opinion in Saccharidis, then the tribunal would have to make an overall assessment of his position in the 10 years prior to 2007, with a view to seeing whether his integrating links with the UK had been broken or the centre interest is transferred. This would, in theory, require factual investigation of the period, 1997 to 2007. MG adds to this, because MG, if you remember, I'll go to it in detail if I may, at paragraph 37, says you're not limited to the 10 years prior to expulsion. You can look at 10 years prior to imprisonment.
Yes.
That helps us. That's a relaxation of the case law in this context from Mr. Vomero's perspective. And then Lord Justice Pillar stated in relation to the question of whether the Secretary can now argue that Mr. Vomero never had a PRR, that it would be unjust to require him to prove facts to establish that he had one in accordance with Regulation 15.1. Bearing in mind it would mean adducing evidence relating to matters before 2001, I respectfully agree. Even on the way the ECJ expressed its opinion in Saccharidis, some kind of evidential burden was placed on the Secretary of State to show a rupture. It would be unjust to require Mr. Vomero to have to deal with factual issues prior to 2001 on this point, just as it would on the PRR point, so many years after events, 5 years after the tribunal decision, etc. The consequence must be that we're entitled to assume that there was no rupture of integration or transfer up to 2001. That's the point. There's no rupture with integrating links up to 2001. What's the nature of them? Well, it's lawful residence, at least for 5 years. And I've tried to explain why this is not a windfall. It's a classic situation of Surinder Singh. And the length of time as well. It's not just 5 years. He's been here for 16 years up at 2001. And that's the important background for the sentences at 127, which concerned my Lord Mance and my Lord Wilson. And so we say that this is a sufficient consideration of Saccharidis. If it's not, MG doesn't make any difference at all. My learned friend doesn't think it does. If you look at his printed case, it's very clear that the Secretary's submissions are entirely defensive on MG, because what is said at paragraph 61 is that it is anticipated, that's MS 120, that it's anticipated that Mr. Vomero will seek to rely on the decision in MG. And at 63, paragraph 63, MS 122, the Secretary suggests that the guidance in MG concerns whether enhanced protection applies where the person concerned hasn't been in prison for 2 years. It doesn't apply to a case such as the present. So, and that's despite the fact, I'll just give you a note, that in her grounds of appeal to this court, the Secretary had said that the questions in MG were, and I'm quoting, particularly pertinent since they cover much of the same ground as the present application. And the reference for that is MS 37, paragraph 3. So up until PTA, it was said that MG is really important, particularly pertinent. Once we get MG, no reliance is placed upon it by the Secretary of State. Instead, she anticipates that we'll rely on it, as I will. And it is further said that it just doesn't apply to a case like this. So the Secretary is not saying that MG makes the situation any worse. We say, in one sense, it relaxes the case law because it allows 10 years prior to imprisonment to be taken into account. And it's certainly, there is no, we say, material change. My Lords, my Lady, with that overlong introduction, may I take you to MG itself? Lord Reid asked the question as to the importance of the fact that the Advocate General didn't give an opinion. We can provide you with the relevant provision, but the relevant provision is Article 20 of the statute of the CJE, which paragraph 5 says, so it's Article 20, subparagraph 5 of the statute, which says that where it considers that the case raises no new point of law, my Lord's absolutely right, no new point of law, the court may decide after hearing the Advocate General that the case shall be determined without submission from the Advocate General. And we therefore say that where there is no Advocate General, it's necessary to identify the relevant previous judgment, which formed the cornerstone of the court's reasoning, and which the court intended to follow. In MG, it's clear we say that the fundamental building block of its reasoning is Saccharidis. It is referred to, we'll see, I'll give you the paragraph numbers now, at 23, 25, 26, 30, 35, 36. Malone Fred says, oh, it's Saccharidis and Onoquere. Onoquere gets one mention. At 31, it is a 5-member chamber, and as my Lord Wilson noted, on Onoquere, the Advocate General Bott, goes out of his way to say it's different. Article 28, enhanced protection, is different to permanent residence. So it would be very surprising if Onoquere was the governing underlying case. It's very obvious that the Grand Chamber decision, we respectfully submit, in Saccharidis, has that status.
It doesn't necessarily have to be either or, does it? I mean, they treat Onoquere by analogy as supporting the conclusion that periods of imprisonment can be taken into account as interrupting the continuity of the period of residence required. But then they apply Saccharidis and saying that even though that's so, nevertheless there has to be an overall assessment made of whether the integrating links that had previously been created have been broken.
Yes, but if you're, my lord, of course I accept that, but if you're looking at what decision the court is simply applying, if you like, to a new factual situation, it obviously, with great respect, cannot be on a query.
Well, no,
because
you're
on a
not
query
looking at that.
concerns
You're asking whether any new point of law is necessary, and the fact that one case is referred to for 5 points and another for 1 really doesn't help us very much. They're both points of law of relevance, and
Yes.
so they thought there's nothing new in anything they're doing.
Yes, and that's perhaps the important point, that we shouldn't treat the case as having been intended to lay down any new
Yes.
principle of law.
Indeed, in a context where honor query is dealing with a separate provision, Article 16, in a context where honor query says imprisonment gives rise to a bright line rule, as my Lady Hale observed, Article 16, imprisonment, bright line rule, you can't count it for the purposes of acquisition, it interrupts continuity. Very clear, easy to understand. In the context of Article 28, the position is essentially, as my Lord Mance put it, in principle, defeasible by reference to Saccharides. Perhaps we should go to MG.
Do you want us to take MG as establishing some new law, Mr. Hussain?
No.
I thought you said it rather importantly relaxed the test.
It applies Saccharides to say, well...
No, quite apart from applying Saccharides, which of course it does.
Yes.
It also, I thought you said, made an important new development, because it said that you could, when you're considering enhanced protection,
yes,
you could look at 10 years, which did not end with the decision.
It says that in terms.
Yes.
My Lord was absolutely right to put that to me. I did say that. And I would say that that is inherent in Saccharides itself.
I see.
Well, the trouble is, I mean, the court may not correctly perhaps have appreciated that it was extending prior law.
Correct.
Without the benefit of an Advocate General's opinion, sometimes decisions are not perhaps going to be as closely reasoned.
Yes. Or the court may have thought that, as I was saying a moment ago, that what it says is inherent in looking at Saccharides properly.
Yes. Well, may well have thought.
So, my lords, you've been taken to MG already, but I want to spend a little bit of time on some of the provisions which we say are important. So, MG, you've got it's at tab, volume 2, tab 13, I'm sorry, thank you, my lady, at page 876. And the relevant passages I wanted to take you to, sorry, begin with 31, the reference to onoquere. And here you've got the proposition that I referred to earlier, that a clear bright line rule is established for the purposes of Article 16.2. When interpreted 16.2, the fact that the National Court has imposed, I'm reading from paragraph 31, my lords, at the foot of 884. When interpreted 16.2, the fact that a National Court has imposed a custodial sentence is an indication that the person concerned hasn't respected the values of the society of the host member state as reflected in its criminal law. In consequence, the taking into consideration of periods of imprisonment for the purposes of acquisition by members of the family of the right of permanent residence as referred to in 16.2 would clearly be contrary to the aim pursued by that directive in establishing that right of residence. And then they say that since the degree of integration concerned is a vital consideration underpinning both the right of permanent residence and the system of protection under expulsion measures, we accept that interposing, but that doesn't mean it's relevant in the same way as the rest of the paragraph makes very clear. the reasons making it justifiable for periods of imprisonment not to be taken into consideration for the purposes of granting a right of permanent residence, or for such periods to be regarded as interrupting the continuity. My Lord Mance said it is bifurcated here, not take into account, interrupting, needed to require that right, must also be borne in mind. That's the phrase they use. They inform but do not dispose of the question when you look at enhanced protection. Inform but not dispose, borne in mind when interpreting Article 28. And then here we say that 33 is not internally inconsistent. It's not internally inconsistent for the reasons my Lord Mance gave. It is externally inconsistent, the first part of it, with 35. It's very clear it's inconsistent, we respectfully submit, certainly on an ordinary reading. And the reason for that is as follows. 33, it says that periods of imprisonment can't be taken into account. That seems to be a categorical statement for the purposes of granting enhanced protection provided in Article 28, and that in principle, such periods interrupt the continuity of residence. So you could, what they seem to be saying is if you've got a situation where, let us say you have 8 years residence, 1 year in prison, and then 2 years residence again, and then expulsion. So you've got 8, 1, 2. They seem to be saying is you can finesse out, in principle,
What is the one?
Imprisonment.
So the 2 is ordinary residence.
Exactly.
Okay, right, sorry, yes, you finesse out the 1.
You can't count the 1, that's what they seem to be saying, but you can finesse it out, and you can count round it, and 8 plus 2 adds up to 10, and whilst in principle the 1 year would interrupt continuity, it needn't do so. So that's consistent. It's internally consistent, that paragraph. However,
Where do you get that from, 33?
Yes.
You get that from 33,
Yes.
do you? I can see why you get it from 30.
No, 35 is something else, my lord.
7, I was going to say. Yes, all right.
Sorry.
Go on.
Sorry, 37 is something else again.
Yes, all right. I'm sorry, I shouldn't have interrupted.
Not at all, my lord. So 33 is internally consistent. We'd accept that. I think our printed case, we said something different. I think everybody's found this difficult. But we accept it's internally consistent. It's
Inconsistent.
It's consistent.
Ah, good.
For the reason you gave, my
Yes,
lord.
right.
The reason you gave.
I'm happy.
But 35 makes the first part, 35 cannot be squared with the first part of 33. Because 35 says, as for the question of the extent to which the non-continuous nature of the period of residence during the 10 years preceding the decision to expel, it doesn't say during the 10 years plus. It's saying you're still looking at the 10 years. Now, if you're accruing 10 years, you've got to count the period of imprisonment.
Wait a minute.
You have to.
Well, you didn't have to in this case.
No, as a matter of principle, in theory, the abstract model.
Why?
Well, because
If you exclude it, you don't have to count it.
No. Because in 35 they're saying when you're looking at a particular unit of time, the unit of time is 10 years preceding the decision to expel. So in my example, it would be, I suppose, 712. Not 812, it would be 712. You're looking at that unit of time. You have a year's imprisonment in the 10 years, 712. You're required to conduct an overall assessment to see whether or not it can be said that the individual resided in the host member state. Therefore, you've got to count the 1 year in order to make up the 10 years. The only way around that is to say that the 10 years is referring to a non-continuous period. But that's not what they're saying. That's a very strange reading of 35. This is perhaps where unanimity in the judgment isn't a great thing. I don't know if that's a convenient moment.
I was going to suggest that before our heads get any more confused by trying to work out whether these various sentences can be reconciled with one another, we better have a break. We'll look forward to hearing from you again at 2:00.